Now that we understand that a mortgage is a lien, it's not the loan. We beat that up in the previous module. But anyway, the mortgage is the lien. This is the security for the debt. All right. So what we're getting ready to look at now are some of the more common provisions you would typically see in a mortgage. So when one is borrowing money, obviously the borrower agrees to provide the mortgage. That's why the borrower is considered the mortgagor. They're giving the mortgage to the lender. That's the security for the debt. Again, mortgage is not the loan, right? So let's see what the borrower is agreeing to when they sign the mortgage over to the lender. First of all, in this first bullet, it says that a mortgage must contain all the essential elements of a valid contract. And obviously that, I think, might even be the next chapter we'll be actually talking about is contracts. But what it's saying here is for a contract to be valid, and for a contract to be valid means it would also be enforceable. So the only way for a contract to be enforceable, like in a court of law, it would have to be considered a valid contract. Well, contract law states there are certain essential elements. There are things that must be included in the contract and agreed upon before the contract would be considered valid. And because a mortgage, it is a contract, it must contain all the essential elements for it to be valid. Now, what are those essential elements? Y'all will be talking about those when we get into the contracts chapter. But then the next bullet is saying that a mortgage is subject to the statute of frauds. And again, you'll see the statute of frauds again in the contracts chapter when we get to it. But basically, the statute of frauds is a federal law, national, that basically says any type of contract that is subject to the statute of frauds, it must be in writing in order to be enforceable in court. So, not all contracts are subject to the statute of frauds. So, in other words, not all contracts are required to be in writing to be enforceable, but here it says a mortgage is subject to the statute of frauds, therefore it must be in writing. So when we get into contracts chapter, we'll talk more about the statute of frauds and talk about exactly what kind of contracts are subject to this statute and which ones are not. But now we get into more specifics of the mortgage itself. Obviously, it must identify who the parties to the mortgage would be. Obviously, the borrower, who's the borrower, and who's the lender. The mortgage will stipulate if title will convey or not. In other words, in fact, if you recall in the last module, we went over the difference between lien theory and title theory, right? Some different states operate under different theories. Some states operate under lien, some under title. And if you recall, those that operate under lien theory will use the mortgage as security. But the states that operate under title theory, they use that deed of trust where there's a trustee that basically will hold title until full payment has been made by the borrower. So obviously that depends on the state that you live in, on which one will be used. But then you see a term here called hypothecation. Hypothecation just means the borrower agrees to put the property up as collateral, but they do not give up possession. Because remember, once you buy or close on a house, you do get equitable title, which allows you to keep possession, to use the property, to live there. So you're not giving up possession when you sign the mortgage, but you are agreeing to put the property up as collateral, right? In other words, if you quit making your payments, we can come take the property from you. But while you're making them payments, you will be allowed to continue using the property. Then there's a provision dealing with assignment. Y'all, does the lender have the right to assign or sell the loan that they made you to some other entity? Yes. Typically, they have the right to do that. Now, if they're not going to do it, they may not have that provision in there, but obviously they must have that provision in the mortgage if they feel like they may transfer this loan to some other party. There's a provision dealing with something called satisfaction, or sometimes you hear it called a satisfaction piece. And what that's saying is this, y'all, obviously, because we know the mortgage is a lien. And that lien is recorded in the public record. Y'all, that's why you will not be able to transfer or sell this property to anybody else until that lien has been removed, right? And the only way you're going to remove the lien is to pay off whatever it is you borrowed or whatever you still owe. But once you have paid everything off, y'all, the loan's paid in full, then the lender will file what we call this satisfaction, which is filed, again, in the public record. And this satisfaction is what removes the lien from the property. Now you're free to sell or transfer the property to somebody else if you choose to do that. There's a provision that deals with the priority of mortgages. And what they're talking about is this. Most people, property owners, will have at least one lien or two liens or three liens, or most people have multiple liens, I guess what I'm trying to say. Because you're probably going to have a tax lien. If you remember, we talked about that a few chapters back. You're going to have a property tax lien. And then most people have to borrow money to buy their house, so they got a mortgage. That's another lien. And then in many cases, people will then go, at some point, will take out a home equity line of credit, the HELOC. That's another lien. And so there could be many or multiple liens on a property. Well, say the owner of the property quits making their payments. Either didn't pay their tax bill, not making their house payment, but they're not making their payments. So whoever's not getting their money is going to foreclose and take the property, right? They're going to take the property, sell the property, and then hopefully be able to use the proceeds from that sale to pay off all the liens, right? Everything that's owed. And if there's enough in the proceeds to pay everybody off, then there's no issues or no problems. But where we run into problems is if there's not enough sales proceeds to pay off all the liens. Can't pay them all off. Well, in a case like that, then who gets paid and who doesn't? And I will tell you the answer is it depends on the priority of the mortgage or that lien, their priority. And if you recall, we said the tax lien will always be the first lien. So, that's the government. The government's going to get theirs first. So, in terms of priority, tax liens are always first. They're going to get paid off first. And then whatever money's left over will go towards paying off your mortgage or home equity line or whatever. But again, we don't have enough money to pay everybody, so which one gets paid? Well, again, it depends on which one has the higher priority. And after the tax lien, then the priority is based on the time and date that the lien was recorded in the public record. Okay? So remember we said when you get a loan, the lender's going to file this mortgage, lien, in the public record. Well, once they do that, that establishes their priority in this situation. And then if maybe a few years later you take out a home equity line of credit, there will be another mortgage associated with that loan. So when they file that, then obviously then they have the next priority under the first loan that you got, right? So the priority of mortgages or liens, y'all, they're established by the time and date the lien was recorded in the public record. Now, what you want to be careful of here, y'all, there could be a difference between the time the lien was executed versus the time that it was actually recorded. Y'all, it is possible, and it has happened, where the first loan, y'all, they might have got a loan to buy the house, even though that was executed first, y'all, if that attorney or whoever did the closing did not go immediately to the county and record it, y'all, that could give that new homeowner, maybe the very next day, they decided to open up a line of credit. Y'all, I'm telling you, investors do this a lot. Y'all, they'll buy the property today, they'll close today, and have it all lined up and ready to open up a line of credit so they can do some work on the house the very next day. Well, obviously the lender that loaned you the money to buy the property, they would want first priority. But if they didn't get down there and record it before the next lender does, then you're just out of luck. So again, it's based on the date and time recorded, not necessarily when it was executed. Then there's a provision called a subordination clause. And this kind of deals with that priority of mortgages. Y'all, is it possible that you could have a lender that has first priority? Could they potentially be willing to give up their priority, allow some other lender to take first priority ahead of them, and then the one that had first priority would just fall in line behind the next lender? Y'all, that's called a subordination clause. Obviously lenders don't have to do that, but typically they will under certain situations. I won't get into all the details there, but that's what a subordination clause is. It's a way for one lender to subordinate, basically give up their priority and allow someone else to take first priority ahead of them. And then there's a provision dealing with non-recourse. Y'all, this happens when the buyer defaults in making their payments. They're not making their payments. And basically what this provision is saying, if I could just paraphrase, borrower, as long as you pay, you stay. But you quit paying, pack your bags. You're out of here. That's what that non-recourse is in essence saying. So you better make your payments. The next provision really kind of lays out a few different things that the mortgagor, which we know again, the mortgagor is the borrower, things that the mortgagor covenants. Y'all, covenant is like a promise, a guarantee that you're making to someone else. So here's some things the borrower, y'all, the mortgagor, promises to do during the life or course of this mortgage or loan. You promise to pay your property taxes. You promise to pay your homeowner's insurance. You promise to protect against removal. Y'all, in other words, don't get drunk playing poker in your garage one night and put title to your house on the poker table. Don't do stuff that could cause you to lose title to the property. You promise to keep your property in good repair. Y'all, when things break, y'all, you promise to make those repairs. You got to fix stuff. Roof is leaking, you got to fix the roof. And then the last one there says you must allow the mortgagee, y'all, who's the mortgagee? The lender, the right of reentry. Y'all, what they're talking about here, y'all, could the lender give you a call one day and just say, hey, look, hope you're enjoying the house you bought, but we'd like to stop by and inspect the house. We want to make sure that you're keeping it in good repair. It's still a good investment for us. Y'all, we just want to check on things and make sure everything's okay. Y'all, could they just show up And then must you allow them in to inspect? Yeah, you agree to it right here. I've never had that happen to me. I've actually talked to others that say they have, but I've never had that happen with me. No lender I've ever dealt with has ever asked to come look at my house. But if they do, you're agreeing to allow them to do that. There's a prepayment penalty provision. Y'all, some lenders, and y'all, depending on the type of loan, y'all could very well have a prepayment penalty provision in the mortgage. Y'all, and it's exactly what it sounds like. Y'all, if you pay that loan off one day early before it was due to be paid off, then you would be subject to a penalty. Y'all, and it's usually a few thousand, several $1,000s. Y'all, it's expensive. That's a ridiculous thing to have in your mortgage, a prepayment penalty. But y'all, depending on the type of loan you get, and obviously depending on the lender, y'all, that's something I would be checking into. Before I ever get a loan, I would make sure there's no prepayment penalty in this mortgage, because they probably won't tell you. They just have it in there, and it's not something they go over. But y'all, sometimes, remember, like now, government loans, FHA, VA, USDA, remember those loans, they do not and cannot have a prepayment penalty. But y'all, you get into some of these conventional loans, they could potentially have it. So you want to check into that. And then there's the defeasance clause. Y'all, that's just a provision in the mortgage that basically says that once the borrower has paid off the loan in full, lender, you must file that satisfaction, remember that satisfaction piece, and have the lien, y'all, the mortgage, removed from the property so I can do whatever I want to do with it at that time. And then the last provision in the mortgage we're going to talk about, y'all, is called an acceleration clause. In fact, this provision has actually 3 different names. Yeah, I hate it, and I'm sure you hate that too. But they may refer to this as an acceleration clause, a due on sale clause, or an alienation clause. If I had to guess, the most popular name, most common name, is probably due on sale. Okay? But basically what this provision does, and the reason it's there, it prohibits the homeowner from allowing anybody else to assume or take over payments on your behalf, at least without the lender's knowledge and approval. You cannot let someone else take over your payments without the lender's knowledge. If they do that, or if you allow that to happen, you're in violation of this mortgage, and they could foreclose on you for that, because you're not living up to the terms you agreed to. We kind of touched on this provision a few modules back, but as a matter of review, do you recall there's one type of loan in particular that if you have this provision, this due on sale clause, if it's in that first underlying mortgage, there's one type of loan in particular that that will not be an option. You cannot do it. And if you recall, it was that wraparound mortgage where you had basically 2 loans wrapped into one. So the homeowner's only making one payment to the bank, and then that bank actually is making a payment to the other bank that's holding the other loan until their house sells. Hopefully you remember that. But if this provision is in that mortgage, a wraparound will not be an option unless you can negotiate this out of that mortgage. So those are the provisions you need to understand about a mortgage.